Good morning, everyone, and especially Professor Frederick Schauer. My name is Celso Campilongo, and together with Lucas Amato and André Luiz Freire, we organized the course Coerção in the Theory of Law, from Hart to Schauer. Along the course, we read and discussed with the students the work The Force of Law, which will soon be published in Brazil by the publisher Martins Fontes, with the translation done by Professor André Luiz Freire. I apologize in advance for not participating in the course, as I will be attending to another activity at the university. I would also like to register that I appreciate the participation of Professor Schauer in completing the last class of this course. It's a privilege to have you with us today, and I'm absolutely sure we are all going to learn a lot from your knowledge and experience. Thank you, everyone, and have a good class. Goodbye.
Welcome, everyone. We have just heard from Professor Celso Campilongo, who is a full professor of jurisprudence and philosophy of law at our University of São Paulo Law School, and he is the vice dean of the University of São Paulo Law School, and the coordinator of the course on coercion on legal theory, from Hart to Schauer, that we had taught in a trio with Professor Campilongo, Professor André Luiz Freire, and myself. And this is indeed a very special occasion, because we have been discussing throughout this semester a single book, which is The Force of Law by Professor Frederick Schauer. Professor Schauer has distinguished himself as a fine legal theoretician with a work that rescues and revises some key understandings and misunderstandings around legal positivism and legal formalism. And this is the case of the book The Force of Law, which comes back to Jeremy Bentham and John Austin in order to challenge H.L.A. Hart's approach to law. Hart opened a line of inquiry in jurisprudence for which coercion and sanctions are not at the core of the definition of legal rules and of a legal system. And the spontaneous internalization of valid rules would be for Hart the internalization of these rules as reasons for justifying behaviors and decisions would be for Hart the core of the legal system, the core of an explanation of legal rules. But here, in contrast, Professor Schauer emphasizes that force and coercion are typical attributes of the social phenomenon that we identify and distinguish as the legal system, as a modern legal system. So I would say that Professor Schauer adopts a kind of Wittgensteinian conceptualization of law in saying that coercion brings some family resemblance among legal rules and in contrast to other social norms. In reference to the role of coercion in the definition of a legal system and of legal rules, maybe one could quote the paragraph 67 of Philosophical Investigations, where Wittgenstein says, "We extend our concept as in spinning a thread, we twist fiber on fiber. And the strength of the thread resides not in the fact that some one fiber runs through its whole length, but in the overlapping of many fibers." So maybe one could capture in this metaphor the omnipresent role of coercion in law and in a modern legal system. we will watch a lecture, and we will have some comments by Professor Schauer on this theme. So I would like to thank very much Professor Frederick Schauer for the kindness of being with us today. And I want to express my gratitude to Professor André Luiz Freire, who is working on the Brazilian translation of the book, The Force of Law, who is a great disciple of Professor Schauer here in Brazil, and who gave me the opportunity with Professor Celso Campilongo of sharing this course for our master and doctoral candidates at USP. I also thank our students who prepared some questions that may guide our conversation today, and the audience can also register some questions in the chat, and we will try to approach them during this morning. Professor André Freire, thank you very much, and the floor is yours.
Thank you, Lucas, and hello, students. I think we have a privilege here today in watching this lecture and having the opportunity to have our questions raised during the course addressed by the author of the book. It's not a usual thing, and Professor Schauer was very kind and in being here with us in this opportunity. I think that the translation of the book was a challenge because, as we could see during the course, it's a very, very deep work, and this work raised a lot of questions during our meetings, very, very deep ones, not just in jurisprudence by itself, but as well in methodology of jurisprudence. Now, we could think a lot about that and how should we should approach to jurisprudence. So it was amazing to debate the book with the students and having now this opportunity. I would like to thank Professor Campilongo and Lucas for inviting me to I'm from PUC, so I'm here in University of São Paulo in having this participating in this course. I would like to thank a lot to Lucas and Professor Schauer, because I did the translation, but they could revise it all, and was very important because they could prevent me of doing some mistakes. And I think we will have the book published next few months. I think it's almost done. And besides, I would like to mention that Professor Schauer has another work published in Portuguese. Is his Thinking Like a Lawyer? It's just published, and I would like to mention that. And I would like not to take too much time, because the important figure here is Professor Schauer. So I just like to come back to Lucas in order for us having Professor Schauer addressing the questions. Professor, thank you very, very much for your time here.
So thank you very much for doing this. Thank you very much for the attention to my work, which is very flattering. I found the questions that were sent to me interesting and a good launching pad for discussion, but let me just talk for just a few minutes before that. And I think I want to address the question of trying to situate what I had to say within a longer tradition of taking coercion as important to law more seriously than current jurisprudential debates seem to. So certainly within, broadly speaking, the modern positivist tradition, or at least more accurately, the modern English language positivist tradition. Bentham and then Austin would be the major figures thinking about coercion as an essential feature of law. But let me mention a few other figures. One, within a somewhat different tradition, Hans Kelsen can be understood, and says on numerous occasions, as stressing the importance of coercion. But for Kelsen, it serves perhaps a somewhat different purpose. So Kelsen, as you probably all know, is noteworthy for developing an account of normative systems. His account of normative systems is largely based on the idea of a hierarchy of normative systems, and at the top of the hierarchy, or at the bottom, depending on which metaphor you might prefer, one finds the Grundnorm, the basis for all of the other norms in the system. But one issue with the Kelsenian perspective is that Kelsen does not give us, by virtue of the hierarchical nature itself, does not give us any reason to distinguish law from any other normative system. Kelsen recognizes this, and indeed, in one of his later works, called Law as a Specific Social Technique, he recognizes that identifying law as something specific or different is important. And in much of the earlier work, General Theory of Law and State, and of course the Pure Theory of Law, what he over and over again talks about force, talks about the application of state force, not because he's overly interested in the application of state force in and of itself, but because for him, a normative system that organizes the application of state force is what distinguishes law from any other normative system. So to repeat, one could apply the Kelsenian system to pretty much any normative system, whether it be etiquette or manners or football or anything else. And for Kelsen, it is the application of that normative hierarchy idea to the application of state force that distinguishes law from anything else. And for those of you who are interested in this, for those of you who follow Kelsenian thought, I should mention that there is a recent book by Christoph Kletzer, K-L-E-T-Z-E-R, German by nationality, but now based in Oxford. And Kletzer elaborates in ways that Kelsen didn't, the idea of law as organizing the application of force in any society. And he explicitly draws on Kelsenian themes. He claims he can find his ideas embedded in Kelsen. Whether that's true or not, I don't know. I will leave that to Kelsen scholars, but it's worth noting the existence of the book and the Kelsenian theme. It's worth also mentioning that there's a very recent book that goes further than I go in locating Force and Coercion at the Center of Law. This is a book by Kenneth Himma, Himma, called Coercion and the Nature of Law, just published about a year ago by the Oxford University Press. And when I say that that Himma goes further, what I mean is that although, as was mentioned a few minutes ago, my approach might broadly be thought of as Wittgensteinian, might broadly be thought of as not thinking that it is appropriate to think of different features as essential or necessary. Himma goes one step further and wants to say that coercion is, in fact, a conceptually necessary feature of law as we know it. His approach is interesting. It's a challenge to at least quite a few contemporary theorists who engage in conceptual analysis of law. And Himma's methodological point is that if we are interested in conceptual analysis, we at least have to start with the concept as it is understood by people who use the concept. And for Himma, if we start with how people actually use the concept of law, how ordinary people actually think of what law is, it turns out that coercion is central to the ordinary person's or even the sophisticated person's understanding of law. He doesn't take that as conclusive about just what law is, but he does take that as a starting point for conceptual analysis in ways that might be understood as challenging the conceptual sensitivities of some number of other modern people who use the same method. That is, one finds increasingly or pervasively in the writings of Joseph Raz references, perhaps indirectly, to our concept of law, what we think the concept of law is, and so on and so on and so on. Himma says, in contrast to Raz, if we are talking about our concept of law, if we are talking about what we as a society think the concept of law actually is, then let's get out there and actually look at what people who use the language and who use the concept think that the concept of law actually is. And if we do that, we discover that coercion has more of a central place, an essential place, a necessary place than we might think. So for those of you who have not had too much of law and coercion by now, I'd at least suggest Himma's book, maybe Kletzer's book as well. And one way to understand all of this together might be that at least over the last 10 years, there has been a renewed interest in coercion, that the view that Hart put on the table and dominated for 50 years is now under increasing attack. And if you like the idea of new paradigms, it might be that there's been a rebirth of interest in coercion. It comes from a number of different angles. It's not just me. I am merely one participant in what seems to be a new wave of interest in force and coercion. Now, methodologically, we might say that my approach is Wittgensteinian, as was just mentioned, but another way of characterizing it is that I want to resist thinking of legal theory, broadly speaking, as necessarily a philosophical enterprise. And I want to think of philosophical enterprises as not necessarily entirely conceptual. So what all of this suggests is that there may be more of a place for empirical inquiry, inquiry that is sociological in the broadest sense, in thinking about the nature of law than people have at least recently assumed. So, but when I say sociological, I don't mean modern sociology as practiced in sociology departments. What I mean somewhat more broadly is empirical inquiry into human behavior, empirical inquiry into social behavior, empirical inquiry into political behavior. So some of this is carried on by sociologists, some by empirical psychologists, whether they be social psychologists or cognitive psychologists, some by empirical political scientists, some indeed quite a bit by empirical economists, some might be historical as well. So one way to understand this is I want to resist the idea of a pure theory of law. Kelsen is often misunderstood in thinking about a pure theory of law. Kelsen did not think that there was a theory of pure law. The pure theory is a methodological point and not a point about how law exists in the world. Kelsen did not claim that law exists in the world entirely apart from other things. He did claim that there was a place for inquiry into law or inquiry into anything else that was purely philosophical, that did not involve empirical inquiry, and so on. So in that sense, he is the appropriate ally of people like Raz, people, more modern people looking at similar kinds of questions in various different places, but Raz principally. Methodologically, I want to challenge Kelsen as well, at least by suggesting that methodologically there may be a place for a form of inquiry, an impure theory of inquiry that mixes the philosophical, the historical, the economic, the psychological, the political, scientific, and the sociological. And that's what I see myself as doing. So I unashamedly draw on lots of other disciplines. I unashamedly draw on lots of other perspectives. I unashamedly draw on lots of other writings that come from various other disciplines. That's impure. It may be frustratingly impure, but it may be impure in a way that I would hope increases our understanding. Okay, that's all I wanted to say by way, broadly speaking, of introduction. Consistent with my instructions from the seminar organizers, what I'd like to do is just talk a little bit about these 5 interesting questions that were sent to me. And when I finish doing that, if there are further questions, if there's time, I'd be happy to address them. Okay, so the first question asks, and I will quote it here, assuming that moral and all other sorts of reasons can play an important role in the interpretation procedure, how important from morals can the conduct imposed by law be? That's an interesting and important question, and I suppose the way I'd want to address it is maybe by challenging the assumption. That is, at least at the outset, want to challenge the idea that morality is a necessary part of the legal interpretive enterprise. So then we have to take a step back and think about what is it that legal interpretation does. So one view would say, and the view that's embedded in the question, one view would say that legal interpretation necessarily involves moral considerations. I would consider that an anti-positivist view, nothing wrong with that, but a positivist view of interpretation would draw on something important that Hart said about legal obedience. So when Hart, especially in his debate with Fuller in 1958, and then a little bit further in the concept of law, when Hart was talking about what we might consider the case for positivism, or the moral case for positivism. At least one of the claims that he was making is that it is important to separate the question of what is law from the question of should we obey it. And I might modify that a little bit in the context of this question by saying that I would want to separate the question, what does the law require, from the question, what should we do with those legal requirements? So one possibility, of course, is that what the law requires itself requires by virtue of a contingent dimension of a particular law, that what the law requires sends us into the moral domain. It incorporates morality by reference, as Raz would put it. So certainly in the Constitution that I know best, the US Constitution, this is a very common feature. Searches and seizures must be reasonable. The state cannot deprive people of the equal protection of the laws. Cruel and unusual punishment is impermissible, and so on. All of these things send us to law. Send us to morality. They incorporate morality by virtue of the, let's call it, the contingent feature of particular laws or particular legal norms. I take this question to be broader. I take this question to be a question about, is morality necessarily a feature of legal interpretation? That is what I understand the assumption to be, and I think the positivist, including me on this, wants to resist the assumption. That is, again, thinking of the US Constitution, One cannot be president of the United States unless one is 35 years old. One cannot serve more than 2 terms as president. There is a right to trial by jury in civil cases, not criminal, civil cases, private law cases, as long as the amount in controversy is $20 or more, and so on. So I believe, some would call this formalism, pick whatever word you want. I believe that one can interpret such language, such legal norms, without reference to morality, that one can interpret the requirement of a president being 35 years old, and so on, without necessary reference to morality. But, and here I come back to heart, that doesn't answer the question of what anyone, including the interpreter, actually should do. That we can determine as an act of interpretation what the legal norm means. But then the question is, should the interpreter follow it? Should the interpreter depart from the law as so interpreted? So if we go back to Riggs versus Palmer, which these days everybody is familiar with, at least I would want to say the New York Statute of Wills did not require morality to interpret it. According to the New York Statute of Wills, Elmer Palmer was entitled to inherit his grandfather's property by the terms of his grandfather's will, without regard to the fact that Elmer had murdered his grandfather. That's what the law says. But then the judges had a task before them. What should we now do? There's certainly consistent with American approaches to much of law. The best view, in my view, of Riggs versus Palmer is saying because the law seems to have produced, because interpreting the law seems to have produced a morally uncomfortable outcome, we should not apply the law as it actually exists, as it actually says. Different legal systems vary in terms of how much they permit this or encourage this, but I want to separate the question of what the law requires from what some legal actor, including a judge, should finally do. Indeed, in current American debates about constitutional interpretation, there are people, perhaps most prominently my colleague Lawrence Solom, who says correctly it's important to distinguish constitutional interpretation from constitutional construction. Interpretation is what does the language mean by whatever appropriate methods we want to use. And then construction is how do we apply that language to particular controversies. I think one can say that morality applies to the construction part, but not necessarily to the interpretation part. At least for me, and I think this is central to positivism, and indeed it's why Dworkin used Riggs versus Palmer as an attack on positivism. Not only is morality not a necessary feature of law in all possible legal systems in all possible worlds. Morality is not a necessary part of interpreting all possible legal items in all possible legal systems in all possible legal worlds. The question is important. The question you raise is huge, but it goes to the fundamental questions of positivism and its opponents. So that's why I want to resist the assumption. Okay, so let me turn to the second question, which is deep and complex. It is about, I'll put it in my language, it's about multiple causation. It turns out that almost all acts are caused by multiple causes. And what do we do when we are thinking about multiple causes? How do we identify what is a cause? One view, if we are thinking about the causes of particular acts. So let me go back a moment. I think when we're thinking about causation, we are thinking about it in one of two very different ways. One, what is the cause of a particular event? What is the cause, for it to use the same example, what is the cause of Elmer Palmer poisoning his grandfather? And when we are thinking about cause in that way, it is common to think of cause in a deterministic way. That is thinking of causation in terms of that set of individually necessary and jointly sufficient conditions for some consequence, some event to actually happen. But that's not the only way we think about causation. Think about the common claim, smoking causes lung cancer, or spicy food causes heartburn, or something of this variety. Here, what we are, nobody would claim that every smoker gets lung cancer. Nobody would claim that the only way to get lung cancer is by smoking. So smoking is neither a necessary nor a sufficient condition for getting lung cancer. Nevertheless, when we say correctly that smoking causes lung cancer, what we are adopting is a probabilistic conception of causation. Under a probabilistic conception of causation, something is a cause of some effect if it increases the likelihood of the effect in an individual case or increases the incidence of the effect for some population. And I think it is important at the outset to distinguish between these deterministic conceptions of causation that we use when we want to assign responsibility for particular acts and probabilistic causation, conceptions of causation, when we are interested in social science inquiry or when we are interested in making policy that will determine in advance what the policy about some category of acts should be. Now that then comes back to the question as it is posed, and it's an interesting one. As you say in the question, when we are looking at deterministic causation and we recognize that a very large number of things are individually necessary and jointly sufficient for some action to happen, then the lesson from Hart and Honoré and from some number of others is that we pick out from that universe of necessary conditions the thing that is most amenable, most susceptible to legal pressure. And that's the one that we call a cause, even though there might be some number of others. So, for example, I'll stick with my same example. It is a cause of Elmer Palmer's murdering his grandfather, that his grandfather was alive prior to Elmer Palmer administering the poison. You can't kill somebody unless they're alive before you kill them. So their being alive before you kill them is a necessary condition for killing. We don't worry about that. And there are a whole bunch of other things that we don't worry about. What we worry about are the things that the law can actually do something about. And Hart and Honoré correctly tell us that those are the ones that we identify. Those are the ones that we pick out as causes. So now let's go back to the causes of legal obedience, which is what the question was all about. So the causes of legal obedience are many, and we are dealing with an issue of multiple causation, as your nice example of striking a match indicates. But when we are dealing with cases of multiple causation, it's still possible to include or exclude the things that may or may not be necessary conditions. If it is true that when we strike a match, both the striking and the presence of oxygen are necessary for the match to light, then scientific method, which isn't limited to the laboratory, scientific method would suggest that we should try to, in theory, strike the match in a room with no oxygen to see if it lights, which it won't, or put the match in a room with oxygen and don't strike it and see if it lights, which it won't. And that would suggest that both striking and oxygen are necessary conditions. There's nothing about the scientific method or the attempt to isolate a variable, to put it more precisely, the attempt to isolate a variable that excludes the possibility of there being multiple causes. So it is, as I said, what makes all of this relevant is the question of what is the relationship between law and what people would have done anyway in the absence of law, to thinking about the nature of causation and the role of law in causing behavior. And the problem comes up when we confront some number of laws, as most laws actually do, and perhaps as all laws should do, when law requires that which is actually morally correct. So there are laws against murder and burglary and rape. I don't engage in any of those activities. Take my word for it. But even if there were no laws against it, I would still not engage in any of those activities. And that then leaves open the question, what effect law as law has on my behavior? That is law a necessary condition for my behavior? And in those examples, it turns out that law is not a necessary condition for my behavior. And then we switch to other instances in which people have an inclination to do something different from the ones I've talked about here. Maybe people have an inclination to not pay their taxes. And then the question is, if there's a law requiring them to pay their taxes, none of us like to pay taxes. If there's a law requiring them to pay taxes, what effect does the very fact of there being such a law make on their inclination to pay taxes? And we can again apply the same kind of methodology. We can imagine, in theory, doing an experiment in which we tell our experimental subjects, it is against the law not to pay your taxes, but there are no penalties attached to not paying. That is, we try to create an experiment in which coercion is removed from the equation. And that would enable us to determine, at least in the context of taxes, whether the fact of law itself removed from its coerciveness actually had an effect on behavior. As I suggest in the book, and there actually is some more recent experimental work by Holger Spamann, S-P-A-M-A-N-N, of the Harvard Law School, consistent with this. Try to do an experiment or set up an experiment or locate a natural experiment in which we isolate law, that is, we add law to the equation, but take out coercion from the equation. And it turns out that the mere fact of law most often perhaps, makes no difference to people's behavior, although this varies from society to society. That's the reason for my example of people in Finland standing obediently on the curb when the sign says don't walk, even if there are no police officers or anyone else in the vicinity, and even if there is no danger. So this long answer to the question suggests that nothing about the experimental method, the scientific method, or the attempt to isolate variables excludes the possibility that most behaviors in the world are the consequence of multiple causes. And the conceptual, theoretical, or experimental task is to try to determine which causes are necessary, or if not necessary, which causes contribute, and if so, how much. So at least it's my claim, based on the experimental research that now exists, based on my interpretation of some number of examples, that law as law, the mere fact of law, independent of coercion, independent of force, is a less important factor in determining behavior than many people think. Nothing about that claim requires the belief that law either is or is not the sole cause of behavior. Nobody claims that it's the sole cause of behavior. The real question is, how often is law without coercion at least causal? Does it increase the likelihood of behavior in a probabilistic sense? And at least it's my claim that that's less common than we might think. Okay, let me just, I have two computers here and one has the questions up there. They're back. Okay. So the second part of this question, again, is about causation. So maybe at the moment, just so I can get to all of them, I'll leave that, but happy if we have time to come back to questions of causation. So then we have a nice question about the difference between a penalty and a price. So it turns out that the distinction between a penalty and a price is an important one, but it is a distinction that relates very much to the previous question about causation and the role of coercion-free law in causing behavior. That is, the distinction between a penalty and a price is largely a distinction that flows out of the view that the things that we call penalties are things that the law wants to discourage by telling us that it is wrong. So famously, Oliver Wendell Holmes wanted to resist this distinction. He wanted to resist it in the context of contract law. So you make a contract, and if you do not behave consistently with the terms of the contract, if you breach the contract, you must pay damages. So then the question is, how should we think about this requirement of paying damages if you do not comply with the terms of a contract? The traditional view would say that that's a penalty. Holmes wanted to say, no, that's just a price. That what a contract does is says, you can engage in one form of behavior for free. You could engage in another form of behavior, but if you do that, it will cost you something. And we could all think of this in terms of how do we behave when we confront a parking meter. Parking meter charges you a certain amount to park in a certain space for a certain period of time. Suppose you know that if you don't put money in the meter, a law enforcement officer of some variety is going to notice this in some form and require you to pay a fine, but it's not going to be a very big fine. So if you don't have enough money with you, or if you want to take your chances, you might just say that one of the things that the parking meter does is it imposes a certain kind of price for parking at a certain period of time. If there is a difference between a penalty and a price, therefore, if there is a difference between a penalty and a sanction, it is the fact that the things that we call penalties are, so it is said, embody the law's view that this is a discouraged form of behavior. The law actually does not want you to do this. In other areas, The law just says you can do this, but it will cost you such and such amount. Indeed, a lot of tax law is based on this. There are certain things that the law says you can do, but you will be taxed for it at a higher rate than if you don't do them. The law is not saying don't do it. It's just saying that the price has just become higher. I think if there is a difference between a penalty and a price, it consists in the difference between the state telling you not to do it, or the state saying, we don't want you to do this, and the state saying, we are indifferent about whether you, as between you're not doing it and paying the price. If that difference makes a difference, and this is the point of what I'm saying here, if that difference makes a difference, it is because and only because the state telling you it doesn't like it itself makes a difference. And that, excuse me, that comes back to the question of whether the state telling you that it doesn't like it itself has an effect on behavior independent of coercion, independent of sanctions, independent of the penalties. And if you agree with me that the weight of the empirical evidence is that sanction-free law tends to have little effect on behavior, little effect on changing behavior, then you might say the same thing about the mere fact of the state telling you that it doesn't like it. So I will leave it at that because I think the distinction is important. But so is the distinction between, to come back to what I wrote, so is the distinction between what we would do without reference to the law and what we would do just because it is part of the law. That, I think, as I put it in the book, is Tom Tyler's mistake in assuming that that there's widespread legal obedience, and legal obedience is caused by the moral content of the law. Tyler wants to think that for example, widespread consistency with the laws against murder is largely because there are laws against murder, and I would want to say it's because people think that murder is wrong. They don't want to murder independent of this, and analytically, we cannot know who's right and who's wrong unless we try to isolate this, and the mere fact that law requires people to do things that they would have done anyway doesn't tell us very much about the effect of the law. That's my cute little example of my ordering my dog to eat. She eats when I say eat, but if I put food in front of her and say don't eat, she'd still eat. So the fact that I tell her to eat is entirely consistent with what she would have done anyway, and therefore my telling her to eat is causally inert. That's at least a possibility with respect to law, and that possibility is the kind of thing that can be and should be empirically investigated. Okay, so the next question is one I'm going to not be able to answer. So it's a question by Natalie Verndl about cryptocurrencies. What I know about cryptocurrencies is, to a first approximation, zero. If cryptocurrencies are just another form of currency, as I think they are, and if people can buy and sell things with cryptocurrencies, if it's better to have more Bitcoins than fewer Bitcoins, then there's nothing about the idea of a cryptocurrency that's distinctive from any other kind of currency, at least in terms of the basic idea of coercion. But as I said, I know virtually nothing about cryptocurrencies other than that you can buy and sell them, and other than that there's a market for them, and other than that the rates for them tend to go up and down the same way the stock market goes up and down. That might be sufficient to say, at least for my purposes, there's nothing different about it between a cryptocurrency and any other form of medium of exchange. If these are things that people want, then it can be a device for coercion. Withdrawing it can be a sanction. And indeed, I might say, as I say a little bit in the book, that we can say, as some economists have correctly said, we might say the same thing about reputation. Nothing about my view about using money as a sanction suggests that money is the only possible form of non-physical sanction. Anything that people value or disvalue and that can be granted or withdrawn can be a sanction. And therefore, reputation can be a sanction. That is, people might do things because it helps their reputation, avoid doing things because it would hurt their reputation, and therefore the threat of granting reputational benefits or imposing reputational liabilities can also be a sanction. So money is the most common form of non-physical thing that a legal system grants or withholds, but there's nothing about money as money that differentiates it for my purposes from anything else that people might value or disvalue. Okay, final question here is about non-state forms of power. Here again, the question is important, and indeed, although the question is put in terms of Max Weber and organizing the state's monopoly on the legitimate use of force, I might suggest that Christoph Kletzer's recent book is relevant to this as well, how should we think about the state and private uses of force? It seems clear to me that the monopoly language from Weber is obsolete. That is, the state does not have a monopoly on the legitimate use of force. The state might, as Kletzer says, have a monopoly on determining which uses of force are legitimate and which are not. And that's different. And that suggests that non-state force, non-state power, or self-help, as it is sometimes put, is an important and increasingly important topic as we think about law and coercion. But one of the things that law can do is that it can authorize private parties to engage in legitimate physical coercion, such as, for example, immunizing self-defense in the law of assault or the law of murder. So at least the law's view is that if I attack somebody physically, and they defend themselves by attacking me in return, one of the things the law can be said to be doing is legitimizing their retaliatory attack. And the law thinks that by legitimizing their retaliatory attack, it might discourage me from engaging in an attack in the first place. Whether that's true or false, we don't know. That's also an empirical question, but it is an example of the law making legal what might otherwise be illegal. It does so by making certain sports, boxing and wrestling, legal. Law has, it authorizes the use of force in those contexts, even though they might otherwise be simple assaults or simple batteries. So one of the things that the law does is authorize private uses of force in this way, but it also does it with increasing frequency by hiring, in effect, hiring private appliers of force by privatizing various private uses of force. So here there's an interesting feature of the original American Constitution, original as in as written before amendments in 1787, that deals with this question. So the 1787 original Constitution of the United States, before any amendments, authorizes Congress to issue letters of marque and reprisal, marque, M-A-R-Q-U-E, letters of marque and reprisal, and prohibits the individual states from issuing letters of marque and reprisal. So a letter of marque and reprisal, for those of you who don't know, which is probably everybody, which would have included me until recently, a letter of marque and reprisal is a governmental authorization to engage in piracy on the high seas. So the government issues a letter of marque and reprisal to a privately owned ship. The privately owned ship looks for enemy ships. If it takes the enemy ships, it can then keep whatever it finds on the ships, that is, whatever property it can seize from an enemy ship, it gets to keep. All of this is somewhat archaic in modern times, but what it was, even in 1787, was a way of privatizing naval warfare, and a pretty efficient one. Why build a ship? Why build a warship if you can just tell the owner of a private ship, you go out and sink the enemy. You go out and seize the enemy's ships. And if you do it, we'll let you keep all or some percentage of what you get. That's good for the state because these are the ships of the enemy. It's good for you because you get to keep what you want. And this was a pretty common form of warfare in the 18th and early 19th century. Now we think of this as privatization. Increasingly, we privatize some number of other things, but all of which is to say that coercion, broadly speaking, at least under my view, is an often effective form of, let us call it, behavioral control. The state often wants to engage in behavioral control. And whether the state does that by having its own behavioral controllers that we might think of as the police, or instead authorizing private parties to engage in behavioral control is largely beside the point about the extent to which behavioral control is itself an important and underappreciated form of behavior modification, as opposed to the mere issuing of mandates or the issuing of orders. Okay, I've been talking continuously for an hour and 10 minutes or so. I'm happy to stop for a few minutes or whatever. If there are additional questions or comments, I'm happy to listen and comment.
Please, André, if you want to make your question or comment.
Sure. Thank you very much, Professor. And in the chats and YouTube, people are just noting all the references that you mentioned, and it's been a rich experience for us to hear you. I have a simple question, just almost a curiosity here, because as a country that legal scholarship and legal system is based in the civil law tradition, and it's common in our culture here in Brazil, and I think it's the same in other civil law traditions, to speak about science of law, law as a science,
right?
Especially because I think Kelsen has a great contribution here. We used to teach Kelsen for first-year students for their despair, and I do that with them, with my students at PUC. Because for us it's a very important author, of course, and and one of the most striking things when I went to our beloved University of Virginia is to see how in common law tradition you never used that word referring to law, and I never saw exactly, probably is a limitation of knowledge of mine, a discussion about that. And your book is an important feature of the book. It's about method. I would know why do you think that? Because is the concept of science too related to experiments, and we never do that, or? Just a curiosity.
Yeah, I mean, I think to some extent this is an interesting and important cultural difference. When Kelsen and others in largely the Germanic tradition use the word science, what they are largely talking about is what is in German Wissenschaft. And Wissenschaft in German is an organized study or a systematic body of knowledge. And there's no reason that a systematic body of knowledge has to be scientific in the sense that physics and chemistry are scientific. So to some extent, what we are talking about is a linguistic difference that comes from the fact that there is no obvious single word in English. I don't know whether there is one in Portuguese or not. There is no single word in English that captures what the Germans mean by Wissenschaft, a systematic body of knowledge. Because of that, it turns out that very few American legal theorists would want to use the word science because in English it's too often thought to refer to something that's close to natural scientific inquiry. Now, having said that, there's an interesting historical example. The precursor of American legal education as we know it was probably Christopher Columbus Langdell, of the Harvard Law School, dean of the Harvard Law School in the 1850s, 1860s, and that rough period. He wanted to make law more of a science. But when he talked about law as a science, he was thinking not just loosely of a body of knowledge. He was thinking of something closer to empirical inquiry, but empirical inquiry about legal items, for him, empirical inquiry about the decisions of judges. So what he wanted to do is engage in inductive scientific inquiry into the decisions of judges, with the aim of producing statements about what the law is from this inductive inquiry into what judges actually do. So that requires a common law consciousness. That is, you have to think that what judges do is law, and not just interpretations of law. But if you think what judges do is law, and if you want to find out what the law is on a certain subject, then you would want to engage in empirical inquiry, inductively, into what all of the judges have actually done. And once you've determined what all of the judges have actually done, then you can generalize from that and say, that means that the law is such and such. So that requires a view about what the law, about where the law comes from. And one of the reasons that you don't hear very much talk in American legal circles these days about law as a science is not only because the meaning of Wissenschaft, the translation, is a little different, but also because Langdell's view that you could find out what the law is by this inductive empirical inquiry into what judges have done is thought not to capture the full richness, variability, and everything else of law in a common law system. So it doesn't capture the full annoying messiness of the common law. It doesn't capture the full sort of variability and changeability of the common law. Moreover, especially these days, it doesn't capture the interdisciplinary nature of American legal thought and American legal education. So it doesn't capture the interrelationship between law and economics and politics and philosophy and a whole bunch of other things. It makes law appear more as an autonomous discipline than it actually is in common law systems. Again, we can come back to Kelsen. Kelsen believed that law, or at least that there was a pure theory of law that could be studied as an autonomous something. That view is largely alien to common law legal consciousness so we don't see very much talk about science. So I think there are multiple reasons, but all of which suggests why you will never hear law thought of as a science in a common law system. I'll add one other thing. It is in the nature of the common law that judges have the power, maybe rarely exercised, maybe not so rarely exercised. Judges have the power to change the law in the process of applying it. And if judges have the power, at least in common law theory, to change the law in the process of applying it, then no legal outcome can be deductively extracted from the law as it exists prior to some particular controversy, and therefore law looks less scientific. Okay, I'll leave it at that.
Thank you very much, Professor Schauer. I would like to ask if you have time for one more question.
Sure. Yeah.
João Vitor asked a question considering that you tell in the book that sanctions sometimes do not reach high-ranking public agents, and the question is who controls the controller? And I would like to this question with another curiosity, that is, this question of obedience to law seems to turn into a question of rule interpretation on the part of the authorities of the legal system. So my curiosity deals with the relation between this book, The Force of Law, and your other writings, particularly playing by the rules, because this question of authority submission to law seems to me to have some implication in the role of legal education, legal hierarchy, judicial hierarchy, and other procedural and institutional incentives. So my question is, what do these incentives work as a kind of sanction, as a kind of coercion on the legal interpretation to guide authorities towards a more formalistic style of interpretation, or towards rules defeasibility and a place for some personal judgment? This is my interest in my question for you. Thank you.
Good. I do think that if you think that so let me start with where you started with who controls the controller. This is obviously a very big issue at the moment in your country and in mine. Both of us have live in countries with recent experiences of not very controlled controllers. I think to some extent, the question of who controls the controller at the very top, especially if the controller has control of the police and the army and so on, it turns out that now we have to think about control either in terms of less obvious factors such as reputation, including international reputation. Countries most countries don't like being pariah countries. The bigger your army, the less it matters to you whether other countries think of you as a pariah country. But at least in smaller countries, this makes a difference. It's likely to make a difference in larger countries as well. There are forms of coercion that may not involve armies. Let's take a current example. It's my understanding from reading the newspapers in the last 2 days that the United States is considering boycotting the Winter Olympics in China. I realize that the Winter Olympics is not a big thing in Brazil, but for reasons of weather, Brazil is not considered an important skiing country. But this is a big deal for China. So my suspicion is that, at least at the margin, it's very important for China not to be the subject of an international boycott of the Winter Olympics, because they are interested for commercial purposes or psychological purposes in not having a bad international reputation, or not having a worse international reputation than they already have. So the threat of a boycott would be a sanction. Other countries may react similarly to the threats of boycotts, the threats of things of this variety. So I come back to one of the things I said earlier. Sanctions don't necessarily have to be purely physical. Now, the other part of your question is, how do we relate sanctions to questions about rules? As you say, I'm interested in rules. I like rules. Intellectually and personally and everything else. But I think what connects the two enterprises is a word you used, formalism. That is, the effectiveness of a rule system is largely a function of the willingness of the sanction appliers to apply a sanction for violation of the rule just because it violates the rule, independent of whether the violation is a good thing or a bad thing. So the simple example would be speed limit rules are most effective when the police enforce the speed limits against safe drivers, when under safe conditions. The speed limit is the speed limit is the speed limit. As soon as the rule is taken to be little more than a suggestion or a guideline or a rule of thumb, then it becomes less effective. So the relationship between the two is a relationship of how important is it to enforce a rule with sanctions, even when the application of the rule would not reflect the underlying justifications for the rule. The more the rule enforcer is willing to do that, the more effective a rule system is likely to be.
Thank you very much, Professor Schauer, for your time, for your very precise answers, and for this disposition to have this conversation with us. And thank you, André, for this opportunity. I ask if you want to make some final comment, and I thank you both.
Just to thank Professor Schauer for his precious time here. Was amazing for us to hear you, and shortly we will have your Force of Law translated to Portuguese, hopefully with minor errors of mine. Please, if have someone found this, just mention to me for a second edition. And thank you very much again.
And thank you for your valuable time in translating it. And thank you all for this. And I look forward to meeting you again, all of you again, at some time in the future.
Great.
Obrigado.
Obrigado. Obrigado a todos.
And thanks all for our audience that is participating in the chat. And thank you for your time. See you in the next opportunity. See you.